Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and a big hello to everybody in between. My name is Dan Balkaran, as you see on the screen, and I'm an employment lawyer at Samfiru, Tumarkin, LLP, which, as always, is Canada's leading employee-side employment law firm. Okay, I'm going to be answering all your questions about everything employment law for the next 30 minutes. As always, if you need to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900, as you see on the screen. Please send in your questions. I'll try to get to them all in the 30 minutes or so that we have. But please send them in early. Quite often what will happen is they all come in sort of towards the end of the half an hour. And if possible, I do want to get to all of your questions because you all have very good and quite often quite urgent questions. Okay, great. Let's get into the questions then. Question from Frankie. After 18 years in the job, I've had 3 times been sent for surgery. So we had surgery 3 times. They were not filed as WSIB claims. And just as a note to everybody, the occupational health and safety legislation in each province is different. So I'm not, and I assume that's what WSIB is. I'm not familiar with that. Each time my job role has been given away, now I'm a gopher. Is this a constructive dismissal? Yeah, it is a constructive dismissal. And, well, all right, so let me caveat here. It could be a constructive dismissal. So what is a constructive dismissal? Constructive dismissal is where the actions of the employer have in effect terminated your employment. So, and that can occur either by a change to a fundamental term of your employment that you don't agree with or you don't agree to. So for example, a substantial demotion, a pay cut, hours cut, resulting in a 20% or more cut of your pay. It can be less, it can be 10%, but also with a demotion. So it really turns on the facts of each particular situation. So that's one way to get there. Another way to get there is if the employer is clearly not interested in being your employer anymore, and through its actions, maybe it's trying to force you to quit, but through its actions, it is effectively what we call it law repudiating. It has repudiated your contract of employment. For that second one, there needs to be a lot of evidence to get you there. But if you do, on either branch, you are terminated when you trigger your termination. Okay, so if you continue to work in the changed, reduced role, you are deemed to have accepted those changes after about 2 to 3 months, depending on. We'll go with 2 months, but it can be as much as 3. I've seen in BC anyway. So, Frankie, if this change, the last one was the significant one in terms of your role reduction, and it happened 6 months ago, you may be out of luck. However, the law is really looking at what a reasonable person in your shoes would experience and do. And if, over the course of these 3 surgeries, your role has been reduced and reduced and reduced, at some point it's a death by 1,000 cuts situation, and no, you can't continue working there because it's a radically different role, or they're clearly trying to exit you from the company. And potential problems with how long you've waited after the last reduction in your position to trigger constructive dismissal. So you should talk to a lawyer right away and get some advice on that. If you need to get a hold of us, you can do so at employer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Constructive dismissals, I will say, are generally difficult. In terms of demotion cases, like Frankie's talking about, tend to be the most difficult. There has to be a substantial change. So Frankie's talked about how he's now a gopher. He didn't say what he was before, but if you're moving from, customer service manager to gopher, then that might get you there. Okay, so but those are hard cases. So you certainly want to talk to an employment lawyer, Frankie, and get some legal advice, both on have you waited too long and is the demotion significant enough. Beyond that, you're also going to have a human rights complaint in the jurisdiction that you're in, be that federal or provincial. Sounds like you're provincial based on the WCSIB portion of your question. But you can't lose your job or be demoted or discriminated against in any way because of a disability in every jurisdiction in Canada. And so certainly that occurred here. Generally speaking, not always, I imagine, but as far as I know, it's in most provinces. Let me rephrase that. I know in BC, there's a 1-year limitation period to file your human rights complaint. You certainly should do that in whatever jurisdiction that you're in, because you can't lose your job, be demoted, or discriminated against in any way because of your disability. And that's certainly what happened here. Your temporary disability arising from your surgery and subsequent medical leave. So Frankie, you should talk to an employment lawyer right away. Do you have a case? Yeah, you might. And just to answer the unspoken question that Frankie's asking, why would he want to get to a constructive dismissal? Well, when you are terminated, when you lose your job, and so there's no real difference at law. I mean, there's a strategic difference, but there's no real difference at law between a termination, explicit termination by your employer, and a constructive termination where the actions of the employer are in effect a termination. As far as the law is concerned, they're both terminations. Why would you want to trigger your constructive termination? Because remember, you have to trigger it. If you don't do anything, you're just going to continue on in your reduced terms in perpetuity, and you can't claim constructive dismissal later on. But why would you want to do that? Because once you've been terminated, you have an entitlement to severance, and depending on what your employment contract says and your age, length of service, and position, your severance can be substantial. It can be as much as 24 months. So certainly something worth talking to an employment lawyer about. But that's why you'd want to do it. You'd get to termination in order to trigger your severance rights. And so that's why Frankie might want to pursue that. Okay, Glenn asks, I've been off work for 2 years on disability and finally started back to work on a gradual return. Okay, Glenn, I don't know if your question got cut off, but there's no question there. So if you have a question, please send it in. Question from HF. Oh, okay. Moderator is telling me that Glenn's question is in different parts. Just bear with me a second. So Glenn says he's off work for 2 years, returned to work, gradual disability. His management position was eliminated, but they put me in a regular employee position with the same pay. Okay. Could they terminate me when I'm off gradual return? I'm a 19-year employee. I'm sure they could, but I wouldn't recommend that if I were them, because they'll have a human rights complaint from you in addition to whatever severance claim you're going to bring, if any. You may have a constructive dismissal based on the lines of what I just talked about, and a human rights complaint regarding the fact that you're no longer a manager and that you're a regular employee. But was your position actually eliminated, or did they give it to somebody else because you were away when you were sick, or on your medical leave, I should say? So those are questions you want to ask. And again, there's a temporal time limit to them. So if this happened a while ago, then you may not be able to claim human rights damages or constructive dismissal, but worth it to look into it, talk to a lawyer about that. But your question seems to be, can they terminate you? So an employer can terminate you at any time for any reason, barring a human rights protected ground. So they just have to make sure your only legal right in the event of your termination is severance. So provided they pay you the right amount of severance, the employer can terminate you at any time. But the closer in time that an employer terminates you following a substantial medical leave, as yours certainly was at 2 years, the more likely it is that a human rights adjudicator says, well, no, the reason why the employer terminated Glenn was because he was away with his disability and now came back and they don't want to employ him. Maybe they replaced him with somebody else. Maybe they're worried about medical frailties, time off, who knows? But it's much more likely if they terminate you in a short amount of time after you return that you're going to have a human rights complaint, which could be substantial depending on the situation. So yes, they could. Will they? I have my doubts, at least not in the first year. I mean, look, I've seen it, so I certainly don't promise anything. But it would be, a legal problem for them, Glenn, if they were to do so. We'll just say that. HF asks, if an employee, and sorry, one caveat, Glenn, to that is if, however, it's part of a larger restructuring, major change in operations that's not Glenn specific, then it can't be discriminatory. But if it's discriminatory against Glenn, if they have legal advice, they may want, and they may not. Maybe a small employer who doesn't have the benefit of legal advice and doesn't know. But if it's a larger employer, I think it's less likely that they terminate you in a really short amount of time after your return because of the legal liability they would incur. Okay, HF asks, if an employer must provide pay in lieu of notice of 2 weeks, does that mean an employee is still entitled to severance? If so, how is that calculated? Okay, this is a good and frequent question. So when you are terminated without cause, when you lose your job, the law has decided that the employer must provide the employee with notice, with a heads up. Hey, HF, the bad news is we're going to terminate you in a month. Just using a month as an example. You'll get a paycheck for that month. The good news is we'll give you time off to look for another job, and hopefully you find one so you're not very unemployed for very long, if at all. That's all you're entitled to at law. It's this heads up, this notice. It's the idea that from a public policy perspective, it's good for society if employers bear at least some responsibility to offset the financial ravages of unemployment on employees. And so it's the idea that you were going to terminate here, but we'll extend that out a little bit farther to give the employee a time to find a job. However, so that's all you're entitled to. It's the heads up and it's called notice. However, if you're terminated today, you're still entitled to the notice. Let's just say it's a month, but you can't get it because they terminated you today. And most employers, for a variety of reasons, are going to terminate you right away, terminate employees right away, terminate, in this case, you today. But you're still entitled to that 1 month notice. But since you can't get it, that notice converts into money, the money you would have received had you worked that 1 month. And that money that you receive for not working for the period of time you should have been given a notice is called severance. So as far as the calculation, the mathematical calculation is concerned, severance and notice are interchangeable, but your legal entitlement is only to notice. So in your question, the employer must provide you with pay in lieu of notice for 2 weeks. Pay in lieu of notice is severance. So that is severance. Whether or not you're entitled to more severance depends what your employment contract says and your age, and after that, your age, length of service, and position. So they are in effect the same thing, but whether the amount that you're entitled to depends on, like I said, what your employment contract says and those other factors. Khalid asks, my union said that I don't get severance pay. I'm on LTD and I get terminated. Khalid, I can't assist you with that. I don't do union side collective bargaining work or any sort of collective bargaining work, so I direct you to your union representative. Peter asks, how should I go about a suspension that happened and all of the issues put in the human resources letter, all of it was not factually true? How should I go about this? I have the entire discussion recorded. Okay, so I don't exactly know what your question is. Oh, you have another part to this. With my boss as to the initial reason I was suspended. I mean, Peter, your question is impossible to answer because I don't know what happened. You didn't specify. I don't think you should specify. I think maybe this is a question you need to get legal advice on, like specific tailored legal advice. If you want to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. I'll just say generally, okay. So you said that not all of the issues put in the human resources letter were accurate. Well, I mean, it depends which ones, right? Are the really serious ones accurate, and the ancillary ones that don't move the needle, are those the ones that are inaccurate? So you'd want to pick and choose your battles on that front. I generally find with suspensions and performance improvement letters, I don't think it matters what, to a large degree, this is just my own personal view of it. I don't think it matters to a large degree whether or not the employer was accurate or not. It has all the power, it has the club, and you have none as against the employer. And what it really wants to hear generally, so either it's trying to get you out of here and no matter what, and that happens. I have clients that's exactly what's going on. The employer just wants to get the employee out, and this is one means to assist the employer in doing so cheaply, because it raises the risk of a just cause termination. Just cause is where the employer can pay you zero severance, and if it can raise enough plausible risk that it had just cause to terminate you, then any post-termination severance burden obligation it has to the employee will be reduced by the risk of that just cause actually materializing. So it could be that that's what's occurring here. It could be that they just simply see it differently than you. But generally, when I talk to people with your comments saying, well, I don't agree with this, well, you're not going to convince the employer by saying, generally again, I don't agree with this. Now, if you have some sort of clear factual claim, like they said that I pulled the switch on June 25th, but actually I was in Hawaii on June 25th, that would be a little bit different. But beyond that, the employer's not going to be very receptive to you saying you're wrong, you shouldn't have disciplined me. What it really wants to hear is, I see your point, employer. I apologize for whatever occurred, and I'm going to take X, Y, and Z. I want to be here. I want to make this work, and I'm going to take X, Y, and Z steps to correct my performance and meet and exceed your expectations in the future. That's what the employer wants to hear. Now, whether or not that makes sense for you, it depends on the situation, depends on your legal position. It could be that you want to treat this as a termination or on the road to termination because you have a big severance payday coming. There's all kinds of different, and you may want to get legal advice on it, but like a full front attack on the employer's position, I don't know how far that's going to get you. And obviously all that is subject to the giant caveat of your employer certainly better than I do based on your one paragraph question. But generally speaking, employer doesn't want to hear that it's wrong. So, but if you are strategically looking for an exit, for example, before you do anything, like with money, before you do anything, you should talk to an employment lawyer. And again, if you want to talk to us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay. I'm not going to say this person's name because it'll identify them. Call them M. My friend of 27 years of service, 55 years old. He got fired. They offered him 26 weeks plus 8 weeks of pay. Okay, so they offered him 34 weeks of pay. That's not enough pay. Your friend should, I shouldn't say it's not enough pay. It depends what your friend's employment contract says. But if your friend doesn't have an employment contract, which it sort of sounds like based on the 26-week offer, your friend should talk to an employment lawyer right away, retain the services of an employment lawyer, and go after full severance. Again, which could be as much as 24 months in your friend's case. Again, if you want to get a hold of us, employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Linda asks, my niece works at a startup and has become a very toxic environment. She would like to give notice, but after reviewing her contract, it has an 8-week notice clause. Does she have to honor that? It's a great question. So if she can, she should. If she breaches that notice clause, and the employer suffers some sort of reasonably foreseeable financial harm as a result of the early quitting, then there is a possibility that she could be liable to the employer for that reasonably foreseeable loss. However, the employer has to suffer a loss. It can't just be because she quit. So for example, Linda or your niece is working on a project. That project is completely, totally owned by your niece, and part of that project is closing a deal with some third party, and instead of giving 8 weeks notice where your niece could have closed that deal, the deal is worth $1 million, she left early and the deal fell apart because only she knew how to make the deal work, then the employer could plausibly come after her for that $1 million. Now, I don't want to scare you. The odds of that happening are very, very small. The courts have been very clear across time that, generally speaking, that they don't want to commercially criminalize, for lack of a better term, employment. Employment and leaving employment can't be a risk, given how important full employment is to our economy. So it's very unlikely. Also, what the scenario I'm talking about with actual personal liability for leaving too early, you got to be generally speaking, a senior employee. I don't think a rank and file employee would ever qualify for that. So is it, if she leaves early before the 8 weeks, which seems to be a little long, depending on the position, is she going to incur any risk? It's very unlikely. Could it happen? Yes, in certain unique situations, it makes more sense for her to. I shouldn't say it makes more sense if she can do it. I mean, if there's another opportunity, great. Go take that opportunity. But if she can give the 8 weeks notice, it bulletproofs against that very, very small chance that there might be personal liability. I'll also say, depending on how toxic that work environment is, and if she's got evidence of it, real evidence of real toxic behavior, she could claim sexual harassment, that kind of thing. She could claim constructive dismissal and get money on the way out the door potentially. So, you may want to talk to an employment lawyer, depending on what kind of evidence you have about the toxicity. And always, for us, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Peter's back. People are just trying to get rid of me. Are you entitled to EI for termination for cause were to happen? No, if it's legitimate, but Service Canada will review. So it just depends. If they're just trying to railroad you and they don't have cause, you'll still be entitled to EI, but you got to go through an investigation and all that stuff. The employer will not be helpful to you, so it can be challenging. But it sounds like it's challenging anyway with respect to your suspension. Peter, you probably want to talk to an employment lawyer. You may be able to trigger your termination now, depending upon what happened. And I'll give her contact information at the end. Munir is back. He's going to call no contract. Yeah. So yeah, Munir, definitely talk to an employment lawyer. I think it was your friend. Yeah, that's right, your friend. Have your friend talk to an employment lawyer right away. James asks, I was fired because my plant manager was doing a walkthrough and said I was sleeping when he went past my station. Is this enough for cause? Were you sleeping? I mean, if you were sleeping, it could be, but maybe there's a medical reason. If I were you, I'd get a doctor's note immediately. If I were you, I'd talk to an employment lawyer right away first. Get a doctor's note. I'd go see the doctor. If is there a reason for it? If you have I think I had a claim a long time ago where there was, I can't remember if it was sleep apnea or narcolepsy or something like that. I think it was sleep apnea, where there was a medical reason why the employee kept falling asleep. And so they terminated him, but the employer terminated him, but it was, I think they had been made aware of it. And so it was a human rights violation. The termination was a human rights violation. So it could be, if you've got a medical reason, I'd put it in right away. If you don't, and this was just a situation where you fell asleep once, is that cause? Well, I mean, are you a pilot? I know you said you're a plant, okay, but are you in a major safety sensitive position where people are going to get hurt because you fell asleep? Could be cause. If you're the guy who oversees the mulcher and the risk of someone getting mulched is really high. Yeah, I mean, it could be. But at the same time, if you're a 25-year employee with zero blemishes on your record, and you say, listen, I have no idea what happened. I just, exhausted, and I had no control over it. It's probably not cause. Okay. So James, I would talk to an employment lawyer right away. If you want to get a hold of us, you can do so. Employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay. We got two more, which looks like it's one more. Sam asks, what kind of changes can an employer make to remote work agreements? It's a very interesting question post-pandemic. Okay. So to start with, I'll just say, unless you were hired specifically into that situation to work remotely only, and it's in your contract, or even if it's not in your contract, but that was the understanding between you and the employer at the time of your hiring, then arguably, so if you have that, and arguably you are a remote employee only, and the employer cannot change that fundamental term without providing you notice, a sufficient notice. So, if you were hired in the middle of the pandemic to work remotely, the employer can't just say, okay, you've got to return to work now, unless it's provided for in the employment contract. The employment contract says we can recall you to work to work back in the office at any time. And then you'd agree to it. You'd have agreed to it contractually, and you'd have to go back. But if it's left up in the air like that, or you were clearly hired to be a remote worker, they can't then change it without providing you either severance or sufficient notice. Now, most of these remote work arrangements are going to be less than 4 years old, so the notice might be short, 4 months, 3 months kind of thing. Now, but for the vast majority of everyone else who did go to the office and then became remote workers, and now the employers are starting to pull some of these people back either in hybrid situations or full-time, for most of you, you have no entitlement to work remotely. And if the employer says, we want you to come back to the office, you're going to have to go. And if you don't, you probably you're going to be terminated for just cause for insubordination, or you will have resigned. So there aren't really good options there. You have no entitlement to work from home. And I'm not saying that's what your question is, but it sounds like that's what those changes are that are being requested. If you're more productive at home, or you can make a good case for why you should be at home, the best solution is an amicable one, and perhaps the only one, an amicable one with your employer. You talk to your employer, see what you can work out. A lot of employers are having a hybrid model, 3 on, 2 off, or 2 on, 3 off kind of thing. But lots of employers just have a hard blanket policy. No, we're not doing that. And I get that. I before I was a lawyer, I used to run call centers for quite a while for major technology companies. And I can tell you that having all of our call center staff in one place where they were all leveraging each other's their knowledge and expertise in a communal, fun atmosphere was central to the productivity of the environment. And so different employers probably feel that way. Whereas some positions doesn't make sense. If you're a web developer, coder, makes sense for you to work remotely. You might get more done. So it just depends on the situation. But do you have a right to it? No, you don't. And so odds are, Sam, and you can get legal advice on it, but odds are you're probably going to have to do what the employer says, unless you choose to quit and go work somewhere else that provides you with more remote work flexibility. Okay, Linda's back. She's a manager, but she's responsible for setting up and running operations and training staff. I can't remember her initial question. Oh, toxic environment. Quit. Yeah. Okay. Yeah. I mean, about the toxic environment, just see if you have anything there. But, with respect to the quitting, like I said before, if she can wait the 8 weeks, probably better. If she gives the 8 weeks notice, probably better. Besides, you can always give the 8 weeks notice and ask if they can abridge it. Because here's the thing, that employer, depending on how central your niece is to this operation, probably doesn't want to pay her for 8 weeks. They'd rather get the hiring going for her replacement, get her out of here 2 weeks, get the knowledge that they can get, and see if they can come up to arrangement that way. So you might be able to have some sort of amicable arrangement in terms of when she's leaving. Joanna, can you be fired if you have MS? You can't. I mean, the short answer is no. You can't be discriminated against on the basis of disability. However, if you have a medical illness which prevents you, because that particular illness has different stages of progression. If you have a medical illness which prevents you from doing the central tenets, functions of your job on a permanent basis, your employer could argue that through no fault of your own or the employer's, the contract of employment between the two of you has been medically frustrated. Okay, that means that it's impossible for you to do your job because you can't do it because of this medical issue, and because of that, the employer's obligations to you under the contract of employment, including severance, are extinguished. Okay, and so in that situation, yes, the employer can just say, because of your medical situation, you can't do the job. You're not going to get any better. If it's gotten to that stage, you're not going to get any better, and therefore we don't have to employ you and we don't owe you anything. Now, generally speaking, in BC, there's got to be a prolonged absence and then permanent inability to work or to do the job or return to work. But if there's a letter from a medical doctor that says this is her capability, it's never going to get better than this. Arguably, I think the employer could say, okay, well, it's been frustrated here. So that is certainly a realistic risk in that situation. And so I urge you, Joanna, to if this is you're talking about, to get legal advice for everyone. And certainly if it is you, I wish you all the best with your medical situation, and hope that you can, if you choose to work, that you can work for many, many years to come medically. Okay, so Joanna and everybody else, if you want to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Other than that, I hope we had a lot of great questions today. Thank you for those questions. We got through them all, which is great. Join us on Monday for Chris Justice, answering all your questions, employment law, on July 15th, Monday at 1:30 p.m. Eastern Time. Other than that, I'll see you here in 2 weeks. Have a great weekend. Have a great and safe weekend, and I'll see you all next time.